Two more questions back. You. I'm sorry. Behind
Here?
Yeah.
Okay. So we have more than one elected city official here in Colorado Springs who simply refuse to turn over emails that we know exist. They won't do it. Or they've now taken to simply erasing emails immediately. So you have them using their personal accounts and they're communicating back and forth, crafting public policy all along the way. And we cannot obtain those emails. We can't file a lawsuit every time someone does this. And they're very frank about it. I erase my emails as soon as I'm done with them. You can't have them because I don't want you to. What kind of recourse do we have? It seems to negate the whole intent of the Open Records Act.
Well, I can think of two recourses, and I'll let Jim. One is, if you're involved in the news media, to bring the public's attention to this and, shame them into doing the right thing. And then next time there's an election, throw these bums out. That's pretty straightforward. Number two, yes, you can sue. And you can seek an injunction. And you can find out whether or not these city officials are part of a city government that has signed on to a records retention policy on file with the State Archives Division that requires maintaining certain public records for a certain period of time. They are not allowed lawfully to destroy records that reflect governmental action. And I would believe that this municipality has signed on to the municipal records retention schedule, and they're in violation of that by flagrantly violating it. So you do have a legal recourse on that. And then lastly, if they're not destroying them, but they're on some, as I mentioned with Governor Rivera's, charge to, not Governor, Mayor Rivera, send them to my personal email account. There's case law all over the country. We don't have a case in Colorado deciding this. Governor Ritter admitted that the text messages on his cell phone were public records because he read them and he used them as a governor. What was at issue was the billing statements, which he wasn't. But Sarah Palin's emails as governor in her private account, and throughout the nation, it's very clear that records on private accounts that reflect governmental business are public records, and you can sue to obtain them or to obtain backups if they're available on Gmail or other archive servers.
I will say, I've learned a sad lesson over the course of 25 years now as a reporter and editor. Shame has limits. Because it doesn't account for shamelessness. That's a classic, that's a perfect setup for, you've got to put this in front of a judge, and the judge has to say, dear city officials, follow the law, and if you don't, you'll be going to the stony lonesome or paying a lot of money. That's really the only recourse I would think you would have to get it done right.
We're almost at the half-hour mark, the full-hour mark, and I see lots of hands. So those of you have to leave, we'll take you. You had your hand up, and I said I'd get to 5 of you. You'll take your question, and then I can stay for a while longer. I can hear you too, but I won't be offended if people have to get to the next meeting and get up and leave. Last question.
Thanks. Elliot Floyd, I'm an attorney in Denver. I understand that the City of Colorado Springs has released its fee schedule. Is that accurate for requests upcoming? Have you had a chance to review that fee schedule? And have you seen anything that might be out of line based upon that trifling language that you suggested earlier from that, I forget the case you mentioned? And additionally, have you... is it compensable for, if, for example, the city was analyzing under their city attorney's office was analyzing whether to turn something over, would that time the attorney spent analyzing, not actually retrieving the records, but analyzing whether an exception applied, be compensable to the city?
I see Louise shaking his head. No, look, can I tell you that there's a case or that the statute says yes or no on these, on all of your very big questions? No. There isn't. So I can tell you my opinion. Luis can tell you his. Others in the audience can tell you theirs. There isn't a, an absolute correct answer until the judges wearing the robes tell us what that answer is, or the legislature changes it and clarifies it. But the fee schedule of the Colorado Springs government was recently, just last week, released. I think it applies to the police department as well, or is it non-criminal? Okay, that's what I thought. Because you asked about the police records, and I haven't seen a fee schedule for CSPD. But with respect to city agencies other than the Springs Police, I think, they have at least put in place a 2-hour free and 25 pages free, which was an improvement over the first draft. But as I understand it, they're still passing through the actual cost of beyond the initial free 2 hours of search and retrieval. And as I said, if it's not trifling in comparison to the actual time spent, then it's not authorized by the Black decision.
So it's begging for somebody to bring a case at some point.
Yes. And the other question, time reviewing documents, but not redacting or deciding which documents to release. Again, I don't believe that's covered. I don't believe those are search and retrieval fees. That's just part of the government's business of deciding how to respond to a court request. Senator Salazar's bill, Representative Salazar's bill excluded that time from a compensable or recoverable fee. But as I said, he withdrew that bill, so.
Does the city charge for that under their fee schedule?
I don't know that that's specifically included. But, you have to look at their time. At least on the face of it, it doesn't appear to be. But
on the same, along the same lines, they do have a fee for someone who will sit next to you as you inspect records. And that's okay to do that?
To inspect records, no. To make your own copies, yes. The statute specifically provides that if you're going to make your own copies, they don't have the facilities to do so. They can charge the same fees and fee to supervise your making copies so as to make sure they don't get destroyed, etc. But they can't charge you a fee to inspect records.
That's what's in their fee schedule.
And that's another basis for challenging. There were many, many hands over here.
Under the permissive exemption for the criminal justice records, as far as the sheriff's department goes, we've got a case where someone in the county had called 911. This was actually in progress, a gun call. Okay, the guy called the sheriff's office 2 times on 911. The customer also called the sheriff's office. And then the business owner also called the sheriff's office direct line 3 times. Now, we have a major investigative reporter from Denver actually looking into this situation and did a court request to the sheriff. This is Teller County, I don't mind saying it at all. And they refused to provide the 911 call data that this investigative reporter has asked for. Would that be considered a permissive exemption, a 911 call list?
Well, the 911 center is administered by a group of criminal agencies, right? I mean, I know they also provide non-criminal response, including emergency, ambulance and medical and fire, probably as well. So, again, it's not open and shut. It's not black and white. I've litigated over 911 tapes in the past. Under the Criminal Justice Records Act, we lost an accident agreement years ago, where there were 2 incidents where people were shot, literally heard being shot dead on the 911 call. It was reviewed from abuse of discretion, and the district attorney got on the stand and testified that if those tapes were released before those 2 charged criminals were brought to trial, it would compromise the investigation, the usual set of concerns, and the judge upheld the withholding of the 911 tapes. Now, if we're talking about not the tapes, but the data itself, when did the call come? When was a response sent? Was there a response? Again, I think that's of a different nature. I think it probably may still be a criminal justice record agency, but you sort of have to ask what is the basis for withholding it. I mean, that's not going to interfere with an investigation or compromise some defendant's fair trial. Right? I mean, we're just talking about data points.
That's a good point that we should put out there. Frequently when you're in negotiations asking for a record, a very powerful line of questioning to the record custodian is, come on, go with me in your mind. What is the worst thing that could happen if this were released? If they can't come up with anything, frequently you can carry the day without having to jump through too many hoops. If you make them think through the steps, well, yeah, you're right. It's not that big a deal here. Right? So that's another reporting technique.
back in the room, and then we'll come over to you.
We
I
get
meant to address this earlier, I got
We
a
have to
little late.
leave the room this.
Yeah.
Okay.
However,
Last two questions.
if an individual or organization makes a core request, is that individual organization core request public also? Or
Yes.
it is public. When he makes a request, it's public.
Yeah.
If you're investigating some behavior that maybe is or isn't, you have to be careful how you make a request because it'll show what you're trying to do. Is that correct?
That's
Yeah.
a sneaky reporter trick. File a core for all cores.
Yeah.
So it's public record.
Yeah, and there's some agencies that require core requests to be put in writing, and unfortunately, the Court of Appeals has upheld that as a reasonable regulation as well. Because for many, you don't have, other than that, it's not part of the statute. You do not have to put the request in writing per the statute, but some agencies do require it. So if you want to not make a record, do it by phone. Last question, then we have to give up the room.
Okay, so this kind of has to do with false information that might be released. We had a situation where records were under open records were pulled from the sheriff's office regarding investigation about child abuse that had already been resolved and investigated in years previous. However, the only information they released was the record that was still to be investigated, which was the false end of it. So they didn't release confirmation that it had, that the folks had already been investigated and exonerated, and why. So it was a political ploy. And so at that point, I mean, there's a point where open records is detrimental and used in an abusive way.
Well, it's true. I mean, selective disclosure of records can, give a false impression. Non-selective disclosure, I mean, people get it wrong all the time, relying on, public, shared common understanding, common data points. But, you can challenge selective disclosure by saying, I'd like all of the records, and please confirm. With respect to criminal justice records and charges that have been filed, the CBI has a database. You can go online and pay, I think they've up to now $6 a search or something. But you can do a comprehensive listing of all charges by a person's date of birth and last name and determine whether or not there's been disposition on those charges. And then if you find that there's been a disposition, you can go back to the agency and ask for more records. All right, I'm told we have a few more minutes, so here, and then we'll go back to you.
Thanks. I'm Harvey Grasker. So I have been record requesting on election records. So on a statewide basis, that requires requesting from 64 different towns. So I have experience actually comparing the response of one custodian to another. And I know that the Core law allows discretion right now about the charging of fees. And many custodians provide records for free and mail them out, email them out, etc. But there are some, however, that are starting to charge above the 20. Some charge 25 cents per regular page. Some charge more than that now for reasons of supposedly voluminous request, the argument of under redaction or search and retrieval. So I am noticing now that there's a motion towards actually limiting the discretion of those custodians. So not only they would now have to charge a specific fee or connection costs in responding to a records request, and they would have to charge for it in advance. So what your comment about that is, and what that means for the future of Core and with respect to requesters particularly. Also, the secondary question is that there are actually waivers that are built into Core for specific reasons, such as educational reasons. But that requires the custodian to understand what the records requester's purpose is. And my understanding is that's not even appropriate. And in fact, under the intention of Core, it doesn't matter what your purpose is for requesting. So what's your comment about the potential for, actually, I think it limits the discretion in terms of those particular purposes to not charging for those particular purposes.
All right, well, first of all, let me begin with an overarching statement. It's sort of like Jim said. If you have good working relationships with your governmental officials, then they're not going to require everything be in writing, and they're not going to say, well, technically we have 3 days to respond, so come back in 3 days, which is also technically not true, by the way. If the record's available, when you ask for it, they must provide it forthwith. It's only if it's off-site or otherwise in use do they get that 3 days. But if you have good working relationships with your government office, then there isn't going to be this distrust and game playing and gotcha. Whether it's with fees or delay or anything else. Let me address your second point first. It's absolutely correct that you are not required to disclose the purpose for which you seek any record, what you intend to do with it, why you're asking for it. One of our favorite quotes is after former chief of police of Denver said, we don't like these requests from the Denver Post for records. They're just on a fishing expedition, which is what government officials like to say. I say the Open Records Act is a fishing license. You don't need to be clear. Why do I want records? Because they're public records, and the General Assembly and the governor has said, I'm entitled to inspect those records. That's why I want them, because they're my records. They're the public's records. They tell me what my government is up to. That's why I want them. And you can certainly take that position, and it's completely lawful, and it's completely clear that that's what the statute and case law says. On the other hand, if you have a good working relationship with a custodian who says, look, this is going to cost you 2 arms and 3 legs. If you tell me what you're looking for, I might be able to work with you and make it only 1 arm, or 2 legs, whatever it is. And that's fine. I mean, they're not every records custodian out there is meant to inhibit access. There actually are people, and you work with them. So I agree. You have no duty to disclose the reason for your request. On the other hand, if you're asking for a waiver for some of the statutory, and journalism is among the research as one, as you said, there are certain noble pursuits for which a requester is not entitled to, but is qualified to request a waiver of fees. Now, it turns out that provision is only tucked into certain fees involving manipulation of data to generate a record in a form not maintained by the government. But we've argued successfully, as you should, that you're entitled to waive all fees, not just those fees, but any fees. And I'm doing this for the Gazette or the Indy.
Yes, that's it. The template we use has a paragraph that says, hey, this is journalism, please waive the fees.
Yeah. So journalism is one of those recognized noble causes, and for good reason, as is research. But when a newspaper or a press entity gets its hands on records, it's making it available to, thankfully, thousands and hopefully tens of thousands and more citizens. So there's that multiplier effect that justifies the waiver of the fee, despite CU and Aurora Theater shooting. So just as you can ask for a waiver that isn't statutorily authorized, I would say the same is true with these schedules. If the schedules say it's $25 an hour, they're not mandated. I mean, yes, they can be, government officials, if they want to say, I'm going to charge you that because that's our schedule, and I don't have any discretion to withhold it, they're going to do that. But the truth is, they have discretion to turn over records that are not public records. They have discretion to do whatever they want. They're government officials. Whether it's excluded or it's even not a public record, they can give it to you. They can give it to you for free. They can fax it to you. They can make it paper plane and fly to you. They can do whatever they want. And so there's never, as I said at the outset, never any harm in asking and negotiating and making the moral argument. I'm doing this for the public good. I'm doing this for a legitimate research enterprise that is surveying how various entities throughout the state are misapplying the law, whatever it is. And the last point, this is a very good point. One of the ways that we recommend and have proven successful in a whole number of ways, both in terms of disclosure and in fees, is to say, look, I've asked for this from 12 other agencies in the exact same situation in the police department. We have, for years, the Denver Police Department, before the new chief came in, wouldn't turn over use of force reports. So an enterprising Denver Post reporter got them upon on request from Pueblo, Grand Junction, Colorado Springs, Boulder, Sterling. We've got 20 jurisdictions to just turn them over and say, look, you guys are the only police department in the state of Colorado that thinks these things are security details that are, are going to compromise your ability to conduct your operation. Why are you the only ones in the state who take that position? And that's a very effective technique to ask other jurisdictions for the same records that your jurisdiction is withholding and say, what's different about this city than every other city in the state?
Well, I'm just concerned about, I'm thinking that Cora might move in the direction of requiring the collection and payment of fees. And it's taking away discretion. I know you just mentioned there has been an existing discretion. But I'm concerned about losing that discretion when one develops
and if you're referring specifically to 1041, Code 1041, I would not be averse to including a waiver. I still don't believe that saying that a record, this is a bill that's currently in the legislature that guarantees a right of remote access to public records. There have been a couple of situations, not just one, including right here in Colorado Springs, where an attorney for a school board told a reporter from the Dallas Morning News that if you'd like to inspect the records about a former superintendent here, just fly on up from Dallas and you can have them. We have no duty to provide them to you. We don't have a duty to make copies and mail them to you. The Open Records Act just doesn't require it. So the legislature currently has a bill before it that would make clear that that attorney and a couple of other individuals are wrong. You do have a duty to provide a record to a requester even though he or she is not physically present. And the bill language states that before sending the records to such a requester, the custodian shall, I think it says, recover the fees for postage, handling, mailing, any fees associated with the transmission, and any other fees that are already allowed under the law. And you could argue that that is required and that it's not waivable. And I would certainly not be adverse to inserting that it is waivable. But I think if I were making a legislative record in front of the General Assembly, I wouldn't say it absolutely cannot be waived. That's what the statute says. And so everyone knows, because here we're making a record. So no one can waive it because I've said so. And this is now the public record. My record would be, of course it's waivable. Everything's waivable. And if we need to make it more clear, then let's make it clear.
Yes, sir.
There's two questions, can they destroy emails, if you ask for certain emails over a certain period of time, like 7 or 8 years ago, is it possible to recover those emails? Are they out there someplace?
That probably depends jurisdiction to jurisdiction. I mean, some folks maintain archives like that. I'm betting smaller places that are less sophisticated from a technology standpoint don't. I mean, I can think of counties up in Wyoming and Montana where you just be out of luck if you ask for that because they don't exist anymore. But a bigger city might.
They're not on a server out there someplace that you...
They might be.
They might be, but don't bet the farm on that. Okay. It just depends on the jurisdiction.
The other question is, how much damage did 1036 do to us last year?
Which one is 1036? Is
that was the one that the Attorney General came down and...
Oh, that was the exemption, yeah, but then the balance got tacked on to 1036 as well. That was very good. So I'm trying to figure out which portion is 1036. The portion that I was involved with, I wasn't involved with the balance, but people really watched. The truth of the matter is, while there was an ongoing investigation by a state agency, you were not going to get them from a state agency anyway. We didn't know, even though, and I'll tell you honestly, that members of the Press Association and the Broadcast Association, even though there's two associations signed on to that portion of the bill, they were very disgruntled and unhappy members. I heard from you. I understand it was not my, this was a bill that came from the Attorney General's office. In theory, it was, those of you who aren't in the know about this, this was a bill that basically extended the criminal justice record standard with respect to investigation files of non-criminal justice agencies within the state only. It was originally proposed to be every entity, Springs government, city, town, municipality. And it was intended to reverse a decision that was before that came out of the Colorado Court of Appeals. In fact, it had nothing to do with that. But what it does is say that while there's an investigation, particularly from the Attorney General's office, under like consumer protection laws, and they do have confidential investigations. I'm sorry. That while the investigation is ongoing, the records are not available for inspection. And if while the investigation is completed, if there's been a finding of no wrongdoing, no discipline imposed, and this includes medical licensees and all kinds of licensees from the Department of Regulatory Affairs, if there's a finding of no wrongdoing, then the file remains under seal, but the results are released. If there's a finding of wrongdoing of any kind or any disciplinary action taken against any licensee or any individual by this, again, just state government, then the entire file is declared open. And that was an improvement, frankly, over the existing state law. So it was a mixed bag.
Well, it was directly over our case, Landowners United States.
Oh, that's right. It was, yeah. And it had nothing to do with the case because there was a finding of liability. I mean, they went after the two. Yeah, I never understood why the Attorney General was saying that it was to reverse that decision, because the bill that came out and became the law does just the opposite. I'm sorry, you and then you.
Marilyn Morris.
I'm sorry, I've been skipping.
Marilyn Morris, Citizen Center. Coincidentally, I was actually going to ask a similar question to yours. One of the things that we have been seeing recently with respect to the first part of 1036 is that when there is a state agency investigation, not of a criminal nature, things like election complaints, what's been happening is that the investigation has just been put on ice, on hold, with nothing happening. And of course, we can't get any information. I mean, for months and months and months, when we know there is no activity going on. And it's not about to be closed, it's not about to continue. We're even finding this with respect to HAVA hearings, Health America hearings, other hearings of complaints, where the complainant is not able to get any records in the court, even though they may have to show up at hearing because it is under investigation. Have you had any experience with that kind of thing? And how do we get a tail on?
Yeah. The only analogous, I mean, I haven't, in this context I haven't, but years ago, the Gazette asked for a number of audit reports from city agencies down there. And the audit reports had been completed, and the statutory provision under audit says that while an audit is being conducted, it is confidential. The final report of the audit performance of any governmental entity is a public record. By negative implication, it is. And so what they would do is they'd get these audit reports back from the city auditor, and then they would send them to the department for their comment on the audit. And until they got the comment back, they declared it wasn't final. And years would go by with unfinal audits because they did the same foot dragging. And we basically shamed them into saying this is unacceptable. At some point, we're going to need to acknowledge. And they actually adopted a policy that says an audit was final when it was delivered for comment. And to the extent that these agencies are shameable, I think at some point you need to say how long does it take to conduct one of these investigations, and when are you going to complete it, and to bring public pressure to bear. Again, Jim's caveat may not work. But that would be the only suggestion I would have, is to say, bring public attention to this tactic that seems to be an effort to avoid accountability.
So you're not hearing anything about new legislation trying to put some time limits?
I haven't.
It's particularly unusual when you've got something like a public hearing for a HAVA complaint, and only one side can get the data.
Yeah,
what happened in court?
Yeah, I would think that there'd be discovery in that case.
Because they're just It's not a court case.
Is it an administrative law judge type deal?
No, it's the Secretary of State who defends, and he's also the defendant. Not defendant, but he's got a citizen complaint.
Oh, yeah, you painted the picture. I get it.
Last question, and then we're going to cede the room, and everyone has to go back to their lives.
Is there such a thing as excessive requirement to make a core request by government?
I'm sorry, excessive?
Excessive, yes. In the case where there's regular reports that come out, held off the website, force you to require a file request, and then charge for it. This particular case involved the city attorney's quarterly report to city council. It's a standard document, it comes out regularly. Why is there a need to require a core for that?
Yeah, I mean, as you saw in the Gazette's article last week on the fee schedule, there's a growing movement, and this was, we didn't even talk about federal FOIA, but the Obama administration came in with great fanfare. Its very first executive order is to reverse the prior administration's just say no policy on federal FOIA, and to have an open government transparency initiative, and to require federal agencies to post more and more information affirmatively to websites. And I think I speak for the entire press and folks who are monitoring federal government saying it's been a dismal failure, despite...
Not so much on the other.
Yeah. Yeah, no, just talking about the President's Transparency Initiative. And there is a growing movement at the state and local level as well to require, or not require, I don't know of any legislation that is pending, but to call upon government agencies to affirmatively post information, to take advantage of websites, and to not require citizens to ask for information, to be proactive and to actually post it. So there's nothing in the law that does require it. I mean, that's why we have a quorum, because if they don't choose to voluntarily, of their own initiative, post information to the public, you have a right to ask for it. But I don't know that you have a right to demand that they post things regularly. The other question, as I understood you, is some type of selective, they post everything except the one that everyone's interested in. Or the other thing I've heard mentioned about is treating similarly situated requesters differently. That's verboten. That's very clear. In fact, on any of the permissive exclusions, if the indie asks for a record that can be withheld but isn't, they cannot withhold that record from any other member of the press. The statute says so expressly, that if any member of the press asks for a document and is given that document, every other member of the press must be given the same document. They cannot selectively disclose information. And this happened in Aurora with respect to fees. The first requester from CU was charged, aside from yours, I mean, of other agencies that were also paying. They made money hand over fist over there, although it's costing them a lot of money. Anyway, they charged the first requester $400 for a set of records related to James Holmes, and then they posted them on the internet. So that's also...
Is there anything we can cite that draws a line saying that shouldn't require a core request? That should be readily available?
No, there's nothing in the statute that I know of. We're done.
Thank you very much, Steve.